Show. This is a show that talks about everything current in the law of personal injuries and relevant to you, the viewer. My name's Tony Carbone. I'm a personal injury lawyer with 30 years experience. With me tonight I've got Don Maffia, a Transport Accident Commission partner at a law firm. Good evening, Don.
Good evening, Tony. Good evening, viewers.
And also a senior lawyer at a law firm specialised in transport accidents and also Fair Work Australia claims, Alistair Boughton.
Evening, Tony. Evening, viewers.
Tonight, viewers, we've got an update on transport accidents and we're going to be giving you some very interesting cases that do relate to you, the public.
But first, Tony, let's talk about what's in the news.
Fellas, there's been a lot of stories in the news. In particular, we've got the ongoing issue about cars and cyclists. There's this story that talks about doored cyclist dies of injuries. Tell me, Alistair, what are the facts of this case?
As I understand it, a cyclist has been doored, and that is as the cyclist is travelling in their bike lane, a parked vehicle has opened the door, the driver of the vehicle attempting to exit the car without checking their mirrors, and the cyclist has hit the door and it's resulted in a fatality.
Don, I heard a story that so far in Victoria in the last 5 years, we've outlaid $200 million towards compensating cyclists. It just seems to be the ongoing issue about cars and bikes. They sort of don't really mix together, do they?
Oh, look, they don't, Tony. And look, it's just, I call it the evolution of what's happening on the roads. There's more cyclists, more cars, the roads aren't big enough. We just have to share it and we have to keep a lookout for each other. And Tony, just a stat here, an average of 38 cyclists per year suffer serious injuries. This is from dooring accidents.
Well, the figures I just gave you highlight that, don't they?
Yeah, but these are from dooring. So, and it's alarming because now it's resulting in death.
The sad thing about it is when you have an accident involving a cyclist, you generally do get serious injuries, don't you, Alistair? So
Cyclists are a lot more vulnerable than people who are protected by the chute of a car. All cyclists generally have is a helmet and lycra.
viewers, the message is respect each other on the road and just be extra vigilant when you're dealing with getting out of cars and also doing turns. There's a bizarre story, Don, involving a taxi driver who went for the brake pedal, hit the accelerator with very devastating consequences. What happened there, Don?
This happened at the Tullamarine Airport in Melbourne, Tony, where I think the businessman was getting out of a van, taking out his bags from the back, and the taxi driver behind accelerates and literally pins him to the car. And the unfortunate thing for the businessman is he suffered very serious injuries, Tony. His leg was amputated.
And also, the other people were pretty badly injured as well. There was a few people that were struck.
Yeah.
Alistair, just shows you very busy terminals, people rushing, constant pressure.
One of those freak accidents, I think, Tony. The taxi driver says that he accidentally hit the accelerator rather than the brake.
There was the story of the nation of distracted drivers. The Mazda Australia boss, who's been overseas and has come back. Is that what could have happened here? Are we distracted? The taxi driver was distracted by all the worrying about getting fined, perhaps, being in the spot for too long. Who knows?
Well, that taxi driver, just the story before, Tony, that taxi driver was his fourth shift as a taxi driver. So he's a fairly green taxi driver. That story about the Mazda driver, the Mazda boss, he's saying that because now we're so concerned about avoiding fines, and if we go over 1 kilometre over the speed limit, we could be subject to a fine. Drivers are more distracted, or drivers are more concentrated on making sure they don't go over that 1 kilometre. So it means they're still looking at the speedo rather than looking at the road.
Well, a taxi driver was a case of fatigue by the sounds of things. But what the Mazda boss is trying to say is that the majority of fines that are issued to drivers, to motorists, are people just over the speed limit and probably under 10 kilometres. So it sounds like a case of let's grab the cash instead of protecting the community. Is that the impression you're getting?
That's certainly what the Mazda officer's saying, where he's arguing that the fine system is just a way to boost the budget.
Don, I don't know about you, but when I'm driving on a freeway, I'm constantly looking at the speedometer. I mean, I've got it on cruise, but you're always worried because sometimes if you're going down a hill, it does tick over, doesn't it? It doesn't.
It definitely does, Tony, and that's where Mazda have now introduced where the speedometer actually displays on your windscreen. So you don't have to look down to your speedometer. So just go straight, and the line of sight should be to traffic as well. But it is a bit concerning. I mean, if we're looking at more concern about the speedometer, we're not looking around what's going around, and the case studies that we're going to do today just display how crucial it is to keep a proper lookout when you're driving a vehicle.
If you're 5Ks over the limit, it can be the difference between stopping in time or not stopping in time, because the faster you're going, the longer it takes to come to a complete stop.
But what about the balancing between looking at your speedometer because you those few Ks over the limit? You know, you could be severely distracted.
Correct, yeah.
There's that side of
Distraction
it too.
is absolutely a part of it.
Just back to the case study we'll do after the break, Tony, that's exactly where 5 kilometres could have saved or prevented severe injuries sustained by a pedestrian.
Look, I'd hazard to guess that if you're on a freeway and you're 3 to 4 Ks over the limit, it's not going to make a major difference in braking, surely. That's what this is all about. That's what this particular boss is trying to say. He's trying to say that, you know, you 1 or 2 over the limit and you're going to do it on a regular basis.
Distraction might be a bigger factor than over the speed limit of 2 or 3 Ks, absolutely.
Yep. And also, the reverse of that is, or converse, you could be going 5 kilometres under the speed limit and you're even more of a hazard on a freeway, don't you think, Don?
Well, again, it's just on point. There's a case study that we'll do after the break on that point as well.
Yep.
It was a slow driver, causing an accident.
We recently had the bosses of Metro trains, and just after that, a teen dies in relation to a train, Don.
Very alarming. There's another teen on a train hanging off at the back, so near the cabin at the back, and he gets hit by a sign, falls off and suffers serious injuries and eventually, unfortunately, dies as well.
And they've had so many of these, and it affects the drivers and everyone else connected with the train system.
They have, Tony. I think what occurred in this incident was that the teen had broken into the driver's cabin at the rear of the train, with the train driver not becoming aware, and they were fooling around in the rear cabin, and it has resulted in a fatality.
That's the whole point, Tony. The driver did not know.
Yep,
So the driver of the train had no idea what was going on in
And
the
I was
whole
surfing
train.
at the back.
And I was surfing at the back, hanging off at the back.
Viewers, we've got to go to a sponsors break. Stay tuned. After the break, we've got this little odd spot I want to bring up, and we'll get on to an update of transport accident cases. Viewers, welcome back to the show. We're going to be doing an update on transport accidents. Before that, we've got this really curious odd spot matter I'd like to raise with the gentleman with me. A New York healthcare provider has been sued after allegations the company made the staff pray, thank God for their jobs and say, I love you to the managers and colleagues, and dismiss those who protested. Alistair, tell me how good or bad that is.
I think there's a clear unfair dismissal or general protections claim for those employees that have been dismissed. We've got a constitution that provides for freedom of religion, and it's clearly discrimination against those who either don't believe in God or believe in a different religion.
I don't think they were really carrying on about God here, Alistair. I think it's more a case of the employer, I don't know if it was a joke or if it was being serious, but he's saying, appreciate your job.
Isn't this also a case of just bullying, harassment, discrimination? It's the whole, as you would say, Tony, the box and dice. So, I mean, this is just ludicrous. Telling someone, their staff, that they have to tell them that they love them and pray and all those
I don't know
things.
about the loving the boss and that bit, but the fact that they enjoy their work's probably not a bad thing. The first case we're going to do, viewers, today is a matter of Wath and Lafsky. This is that sad case of a youngster on a bicycle that got run over. Do you want to give us the facts, please, Alistair?
Sure, Tony. So Callan Lafsky was a 7-year-old young boy who was on a scooter travelling down a street. As he entered the intersection of 2 streets, another vehicle being driven by Bryn Wath was travelling at an excessive speed and a collision has occurred. The young boy, Lafsky, sustained serious head injuries as a result of the transport accident.
Don, was a big issue in this? It was breach, wasn't it?
Well, look, there's a few issues. It was obviously, at first instance, the boy won the case, and then it's got taken to a court of appeal. So there's a few issues. There's a breach. Was he failed to keep proper lookout on the part of the driver? Also, driving excessive speed, which we'll discuss a bit more in a minute, but also whether or not the accident was inevitable. So regardless if there was a breach of the duty, was the breach of the duty the cause of the child's injuries?
Well, Don, the viewers should know that when you're dealing with minors, the case of Gunnings and Fellows has expounded the following principle. There's a greater standard of care required of motorists when young children are in the vicinity of a road or reasonably expected to be in the vicinity. So that weighs heavily against the driver in this case, doesn't it, Don?
Correct. Well, the first issue was speed. Now, Alistair, what was the speed alleged of the defendant, or in this case was proven because a judge found?
The speed was between 50 and 60 kilometres an hour.
Now, was that in...
I'm not sure if it was 60, Alice. I thought it was around 50.
There were two experts, one of which said the speed was between 55 and 60 kilometres an hour. The other expert said it was between 59 and 65 kilometres an hour.
And what was the speed limit?
The speed limit in that area was 50k an hour. However, the judge indicated that because of the nature of the road, because there was a school nearby, because of the time of day, that the appropriate speed was in fact 40 kilometres an hour, not 50, which was the designated speed limit.
Your opponent said he was doing between 50 and 52, Don.
I think it didn't matter. If he said, even if he was found to do 50, not breaking the speed limit, he would still have breached his duty of care because in the circumstances it was too excessive. The speed was too excessive.
But if the road sign said 50, right, surely why can't he rely on the road signs?
It's not enough. Got to keep a proper lookout and take reasonable care to those around you. And you've just highlighted moments ago that where there are young people around, you've got to take extra care. There was a school in the vicinity and therefore the driver had to take extra care, and that meant reducing his speed below the speed limit.
What about, is the council or the road authority to put the sign up in the gun in terms of some sort of contribution towards the damages?
No, I wouldn't think so, Tony, because I always use the example many, many years ago, speed limits around school were 60 kilometres. Around school during the time...
Well, they're 40 now, aren't they?
They're reduced to 40. But back then, if you're doing 60 around a school zone, all right, and you unfortunately hit a kid, you're still liable. Because despite the speed limit, the point is, even if there's a speed limit and you're not breaking the law, you can still be held liable in negligence because you've breached your duty. You've got to keep proper lookout, drive according to the circumstances. And if the school's in the vicinity or there's children or there's a built-up area, you've got to slow down.
Alistair, there was a finding that the driver didn't see the plaintiff until 5 metres before the accident.
That's right. There was a lot of dispute about where the driver ought to have seen the plaintiff, and various experts were tasked with working that out, taking into account various cars in the street and foliage that may have prevented the driver from seeing the plaintiff, and the court held that the driver failed to keep a proper lookout because the driver did not see the plaintiff when she should have.
What's this debate about the agony of the moment?
Well, there's two bases of that. The agony of the moment is a situation where, let's say you're driving, there's an emergency situation occurred in front of you and you take evasive action and the decision to take that evasive action was reasonable. So let's say you're driving along and something comes in front of you, you swerve and you somehow hit the thing in front of you. Yeah. Like they use the example of if there's an animal on the road, take evasive action to avoid an animal on the road and hit something else. You may not be held liable in negligence. In this case, I couldn't really follow the argument about agony of the moment. I think they were pointing more to what we call an inevitable accident. An inevitable accident is where there's nothing that the driver could have done to prevent the accident or the harm would have happened in any event. In this case, what the defendants tried to allege is that the boy came out of the side street, came on the wrong side of the road and resulted in a head-on collision. So
and
he
couldn't
said,
be avoided.
So he said, even if I stopped, he would have ran into my car.
Yep.
And that was the whole debate. He failed on that basis. Now, Alistair, you can probably tell the viewers about that. Why did the judge find that it was not an inevitable accident?
Well, the judge found that it wasn't an inevitable accident because had the driver been able to stop, that did not necessarily mean that the accident, or it did mean that the accident would have been avoided.
So the court found that if the driver was doing 40 kilometres an hour, this accident would have been avoided.
On the balance of probabilities.
Yeah, I'm not sure reading the facts that I see it that way, and in this case, you can't take anything off for contrib.
No, because
his child didn't know.
He's too young to appreciate any risks that he puts himself in, or to accept that risk, or to, in this case, to look after his own safety. And
But Don, assuming he wasn't a 7-year-old, assuming he was 15, what would you have taken off knowing what you know?
Oh,
Could have been pretty high.
Could have, look.
He was on the wrong side of the road.
He was on the wrong side of the road, but at the same time, you just can't take away from the driver, Tony, that he must take reasonable care in driving the vehicle and keep a proper lookout. And the other thing too is that they did accept that the child who came out of side street, he was trying to get across the street. He obviously couldn't take the turn properly, and he was trying to get across to the other side to have a safe landing on what they're talking about, the grassy verge area. So that's why, look, in this case, the judge didn't accept anything that the driver said, really.
Well, the car's a dangerous weapon, so the driver's always in the gun.
Absolutely. Cars can go very fast and cause a lot of damage.
Viewers, we've got to go to a sponsor's break. Please stay tuned after the break. The next case will make your hair stand. Viewers, welcome back to the show. We've got this interesting case of Waterfall and Anthony, which will make your hair stand. Tell us the facts, Alistair.
Interesting case about a motorcyclist who sued for some compensation as a result of an accident with a vehicle that was towing a caravan. The motorcyclist was travelling approximately 100 kilometres an hour, whereas the caravan was travelling allegedly in first gear 10 kilometres an hour. The motorcyclist attempted to overtake the caravan on the right-hand side of the road, which was the wrong side of the road, and in fact the road was divided by continuous double lines.
It was a very hilly part of the road, I believe, and the caravan was on the left-hand lane, Tony, moved into the right-hand lane. It was looking for a lookout turn-off.
Yep.
Moves into the right-hand lane. The motorcyclist sees, just sees in the left-hand lane, tries to pass him on the right-hand lane, and the caravan moves in. But as it happened, as accepted by the court...
But you can't, correct me if I'm wrong, if you're overtaking, you've always got to overtake on the right-hand side.
That's
you
right.
can't duck in on the left-hand side. That's illegal.
In this case, what happened was when the caravan moved, or the vehicle towing the caravan moved to the right-hand lane...
He should have just stopped.
Well, and then turned. But what he's done is he's actually blocked the left-hand lane. So there was no way that a motorcyclist could have got through the left-hand lane either, because the caravan was partly on the left-hand lane.
So it's taken both lanes.
That's right. And there was an issue about the indicator. Elsa, with the indicators, there was two stories as to what was happening with the indicators.
The motorcyclist says that he never saw the indicator and that alleged that the indicator was never put on. The driver of the caravan says that he initially put the indicator on to move from the left lane into the right lane to make his right-hand turn, and then he put the indicator on a second time as he began to execute his right-hand turn, and that's when the motorcyclist coming around on the right-hand side got hit.
Don, is it fair to assume that this happened really, really quick? Because if the motorcyclist is travelling at 100 kilometres an hour and the caravan and car is travelling at 10 kilometres an hour, you basically would have got there, bang, it would have happened, correct?
It's a split-second decision. The motorcyclist had a view, though. The motorcyclist did have a long view, because it was a hilly part of the road and could have seen what was happening. And the decision was, obviously, when he got there quickly, because he would have got there very quickly.
Very fast.
decision was to go over the double line rather than go left-hand side because the caravan was partly blocking the road. So he thought it was safer and was around.
What caused him to come off the bike?
The collision. So
What did he hit?
The motorcyclist has hit the vehicle that was executing a right-hand turn.
Yep, which was
not
a caravan.
No, the vehicle, because the caravan was still on the right and partly over the left. So it literally just took over the whole road. So that just goes to show, I mean, even though he was overtaking overtaking double lines, the question was whether or not the other driver was negligent, the driver towing the caravan.
What did the court find, Alistair?
At first instance, the court held that the motorcyclist, Mr. John Waterfall, was 60% responsible for the accident, whereas the driver of the caravan was 40%. On appeal, the Supreme Court of Appeal held that it was an even amount of contribution to the accident and amended the decision to 50-50.
Why 50-50? Is it the court saying we don't know?
Look, it's a... in the circumstances, the Court of Appeal somewhat disagreed with the judge at first instance and said, look, the driver of the motorcyclist shouldn't be more to blame for the accident. And I just think that one sticking point for the Court of Appeal was the indicators. When was the indicators applied? The trial judge at first instance, the first trial judge said that there was 2 occasions when we put the indicator, whereas the Court of Appeal seemed to say, we don't accept that, we think you only put it on once, and maybe quickly when he was executing the right-hand turn. So that was a point of difference, and that's probably why it's gone down from 60-40 to 50-50.
Why do you think it was 50-50? Because the cyclist was going too fast?
Well, the cyclist was clearly at fault for travelling fast, but within the speed limit. It should be noted that the speed limit in that area was 100 kilometres an hour. I think the reason the court held that it was 50-50, the motorcyclist took the risk when he elected to overtake across the doubled lines, whereas the driver of the caravan did not keep a proper lookout in executing a right-hand turn, did not give proper indication. As Don said, the caravan driver didn't indicate, as the court held, and did not indicate when finally executing the right-hand turn.
Don, if the caravan hadn't have gone over the double white lines, do you think the driver of the caravan would have been held responsible?
Well, the other point of where the breach come from on part of the caravan or the driver towing the caravan is that they failure to follow correct positioning on the roadway. So he essentially blocked the 2 lanes.
Yep.
So if the motorcycle had not gone over double line, I don't think it would have been a 50-50 because he took that risk.
What would it have been?
Oh, I think it would be more on part of the caravan because he's blocked the roadway.
Yep.
And it's a speed limit of 100. Like, just going back to example, even slow drivers can cause accidents. And this is an exact example on point, where driving at 10, 20 kilometres puts everyone at risk.
Yeah, but driving at 100 in those circumstances puts you at risk too.
It was a straight rule.
This is a classic example of why viewers, if you ever get involved in one of these accidents, you've got to consult people that know what they're talking about. And Alistair, would you have done anything different in this case if you're on the bench?
I think that the motorcyclist was very lucky in this case. The motorcyclist has crossed the double lines and tried to overtake in a situation that was clearly not safe.
You'd make a very tough judge, Alistair. Don, 2013 amendments to the legislation. Do you want to remind the viewers what these are?
Just quickly, last year, 2013, there was a few amendments made to the Act, including the definition of what's a serious injury for psychological psychiatric injuries. But also, Tony, there was just one amendment which we'll quickly discuss. This amendment is what is a transport accident.
Yes.
Previously on the show, we discussed the case of Koutsoulis versus Transport Accident Commission, where it was a lady get onto a bus and the bus driver closed the door. And it was held, well, the TAC accepted that as being part of a transport accident, so therefore entitled to receive compensation through the scheme. The argument the lawyers made was that it was not a transport accident, so therefore it's not going through the scheme, and it's what we call unfettered common law action. So access to common law without reaching all these thresholds. The judge in that case held that it was not a transport accident because it was not an action that was antecedent to the driving of a vehicle. The laws now, Alistair, you could probably just inform the viewers, what does the laws now say about opening and closing of doors of trains, trams and
It's
buses.
now in legislation that any accident involving the opening or closing of a train door will be a transport accident.
What's significant about the changes, viewers, is that you must consult a lawyer. If you've got a psychological, psychiatric injury, if you don't consult a lawyer, you're going to get caught out because you need to get 3 years of treatment and there's other criteria you must satisfy. So it's absolutely crucial that you get advice early in the piece. On that note, it's the end of the show. Alistair, thanks for coming on board. Don, as usual, thank you for coming on board.
Thank you.
Viewers, go to our website, go to Twitter, Facebook, give us your comments. Stay tuned for future episodes and always remember to stay safe.